Chair.
The Honourable Amy Adams.
Mr. Chair. Thank you, Mr. Chair. I did just want to take a brief call to respond to the SOP that Ms. Curran talked about in her first call on this part of the bill, because I do think it deserves a little bit of time to reflect on how we've got to that point. That the SOP, as the member has pointed out, contains a number of reasonably operational changes to legislation, but the one I think that Ms. Curran talked about and I think is worthy of a little bit of time on is the new clause added in the SOP into clause 14 of the bill, and so that does create a very clear provision about the liability of New Zealanders when they commit offences as a party against a child internationally. And so it did come about as a result of the Supreme Court decision in a case called Allium versus and the Queen that was issued by the Supreme Court later last year. And in that case, sir, it was a very sad fact pattern, as many of these cases are, where a New Zealander was found to have been involved in taking sexually explicit photos of their 7-year-old stepdaughter in Russia. And the issue before the appellate court was whether, in fact, the legislation permitted a New Zealander to be liable for an offence committed in another country where the principal party carrying out the offending was not a New Zealander. Now, in that case, sir, the finding was that, in fact, New Zealand law had a gap in it, which was that if the offender was a New Zealander, then all parties to the offence who were also New Zealanders could be liable. But if the offender themselves was not a New Zealander, then the fact that a New Zealander was a party to that offence could mean that they would escape conviction. And so that is certainly not the intention of the legislation, and it would be quite wrong, I think, and against the will of most right-thinking New Zealanders to allow a New Zealander in that sort of situation taking sexually explicit photos of, in that case, their stepdaughter, to escape conviction merely to do with the nationality of the principal offender. Luckily, in that case, liability wasn't escaped because they concluded that the offender was liable as the principal offender, but nonetheless it raised a very serious matter that officials advised me should be addressed in this bill, and sir, I agreed with them, to ensure that we do carry out our obligations under the UN Convention of the Rights of the Child and what's called the Convention on the Sale of Children, Child Prostitution and Child Pornography, to ensure that there is full and effective criminal liability for a transnational offending in this space. So this is one of the categories of offending that I think won't surprise anybody to know is seen of such seriousness and such severity that it should attract transnational liability, and it has always been the intention, or my intention, and I think that the government's intention long before I became the minister, to ensure that liability of New Zealanders should be comprehensive, and certainly when this gap was highlighted through the decision in Allium and the Queen, the decision was, well, the advice that I received from officials was that this bill should address it, and so I agreed with that advice, which is why we have in the SOP before the House now this new provision which makes it very clear that no one can escape liability merely because the principal offender would not have been a New Zealand citizen at the time the offence was committed. So I think that makes good sense. I do accept the point that that wasn't part of the bill when it came before the House, but I wouldn't want to have it resting on my conscience that a New Zealander could escape liability merely because their partner in crime, quite literally, was an offender of a different nationality. That was never the intention. I think it would be an unwarranted hole in the legislation, and that's the basis on which the SOP and the addition of that new provision is in front of the House. So the other changes in the SOP are reasonably prosaic, addressing the Accident Compensation Act to ensure that the new offence of indecent communication with a young person and the existing sexual grooming offences are included in Schedule 3 of the ACC Act to ensure that appropriate support is available. Similarly, that the new offence of indecent communication is added to Schedule 2 of the Vulnerable Children Act, so that anyone found guilty of such offences can have the appropriate restrictions placed on their employment in core children's workforce roles, and so with the indulgence of the House, if I can just mention the technical amendment to Clause 7, which we have already covered in the first part, which just makes it clear that recidivism has to be an offence that was both occurred and they were convicted of, which I think is an appropriate safeguard. So I just wanted to take that call to take the House through the matters in the SOP, very clearly the rationale for them. If the House wants to debate that, I'll be very interested in hearing it.
Tracy Martin.